Committee will come to order. That's one way to bring it to order, if someone fall down. The subcommittee today is hearing testimony on the following bills. HR1157 by Doug LaMaffa, the Santa Fe Band of Chumash Mission Indian Land Transfer Act of 2015. HR2386 by myself, the Unrecognized Southeast Alaska Native Communities Recognition and Compensation Act, and HR2538 by Mr. Huffman from California, and Linton on the Linton Rancheria Homelands Act of 2015. I'd also like to mention that 2 local governments were invited to testify on HR3538, the Seminole County Board of Supervisors in the town of Windsor. However, both were unable to be here today. I'm somewhat concerned we are unable to have an open dialogue with all local stakeholders. I'd like to continue an open dialogue with the bill sponsor as well as any local stakeholders who may be impacted by the bill. Under Committee Rule 4F, any oral open statements at hearings are limited to the chairman and ranking minority member, vice chairman, and designee of the ranking member. This will allow us to hear from a witness who has traveled to testify on these legislative packages. Therefore, I ask unanimous consent that all members' opening statements will be made part of the hearing record if they are submitted by the subcommittee to the subcommittee clerk by 5 p.m. today or at the close of the hearing, whichever comes first. Hearing no objections, so ordered. Also ask unanimous consent the gentlelady from California and gentleman from California, Mrs. Capps and Mr. Hoffman, will be allowed to join us on the dais to be recognized and participate in the day's hearing. Hearing no objections, so ordered. Oh boy, oh boy. As I mentioned, the subcommittee will hear testimony today on 3 bills. HR 1157 would direct the Secretary of Interior to place approximately 1,400 acres of land, commonly known as the Camp 4 property, into trust for the benefit of the Santa Fe Band of Chumash Mission Indians with Santa Barbara County. The bill is sponsored by my colleague, Mr. LaMaffa. The second bill is in our agenda, HR 2386, will provide redress to Alaska Natives from the communities of Haines, Ketchikan, Petersburg, Teneke, and Wrangell. These natives were denied an opportunity to establish villages or urban cooperations under the Alaska Native Land Claims Act in 1971. Natives who enrolled in these communities did become at-large shareholders in regional corporations southeast Alaska. We were denied rights to land and local resources that other villages and urban corporations received under ANSCA. ANSCA prohibits these communities from obtaining an administrative or judicial solution so legislation is necessary. My bill will recognize the 5 communities under ANSCA established urban corporations for the communities and provide the process for newly established urban corporations to negotiate the Department of Interior for selection of surface estates of federal lands that would be conveyed to the corporations as for compensation. The same amount of land and other native villages received under ANSCA. The final bill on our agenda today is 2538, which direct the Interior Secretary to take into trust approximately 511 acres of non-contiguous fee land owned by the Linton Rancheria adjacent to the town of Windsor and the Seminole County deal. Now I'll recognize the ranking member for his opening statement.
Thank you, Mr. Chairman. As always, I want to thank our witnesses here today for taking time to help us understand your views on these bills. Today we will hear testimony on 3 bills. HR 1157, introduced by our colleague Rep. LaMalfa, will authorize the Secretary of the Interior to take 1,400 acres of property in the Santa Ynez Valley in California into trust for the Santa Ynez Band of Chumash Indians. The Chumash have long-standing cultural and spiritual ties to the property, which is located just 2 miles from the current Santa Ynez Reservation. Currently, only about 17% of the tribe's members are able to reside on the reservation due to the fact that the natural terrain is unsuitable for further housing development. Therefore, the Chumash would like the 1,400-acre property, which they already own, to be taken into trust so that they may construct 143 single-family homes for their members. The tribe has no intention of using these lands for gaming, and the legislation includes a specific provision to the effect. HR 2358, introduced by my friend and colleague Rep. Huffman, will take approximately 511 acres in Sonoma County, California, into trust as part of the reservation of the Linton Rancheria. Most of us, especially those members from California, are aware of the federal government's sad history in dealing with the rancherias, including the unjust termination of their status in the late 1950s. With the exception of a small parcel of land that Congress provided for gaming in San Pablo, the Laytons have been left essentially landless and without a reservation since 1961. The new land, which the tribe holds in fee status, will ensure that they will finally have a permanently protected homeland on which they can plan for future generations. Furthermore, I understand the tribe has worked closely with Sonoma County to reach an agreement that protects the sovereign rights of the tribe while sharing any burdens of development. This is a shining example of tribal government-to-government relationships can create positive outcomes for all involved. The third bill, HR2386, introduced by Chairman Young, will designate 5 Alaskan communities as urban corporations under the Alaska Native Claims Settlements Act and grant each corporation 23,040 acres of public lands. While I empathize with the concerns of the village, I understand that there are serious concerns that enactment of these legislations could have sweeping and harmful impacts to the forest and the economy of southeastern Alaska. And I'm looking forward to listening to have deeper understandings so that we can get to the bottom of this. In closing, let me again thank our witnesses for appearing, thank the members who have come to testify, thank all the staff who worked very hard on these bills, and I look forward to your testimony. So thank you, Mr. Chairman, and I yield back.
Thank you, and I would like to recognize the sponsor of the legislation, Mr. Mamalfa, if you have an opening statement.
I do. Thank you, Mr. Chairman, and committee members. Mr. Ruiz, thank you for your comments on H.R. 1157. I appreciate the strong support that the committee is showing here today, so thank you. We're pleased to present H.R. 1157 as a measure with, again, 10 co-sponsors, 8 Californians, and 4 Californians that are members of this committee, subcommittee. This would direct the Secretary of Interior to take land into trust to enable the San Ynez Band of Chumash to address a shortage of housing for their members. The tribe, to its credit, has used its own resources to purchase land to meet these housing needs, has a demonstrated presence in the area dating back to the earliest European contact with California Indians, and the Bureau of Indian Affairs recently announced that it would approve the tribe's application to take the land into trust administratively. Unfortunately, anti-growth obstructionists have already threatened to stall this process with lawsuits. The recorded history of the Chumash area reaches back to the earliest arrival of Europeans in California when Spanish explorer Cabrillo landed on the shores of California in 1542. It was the Chumash he encountered. Beginning in the early 1800s, the Chumash became wards of the Spanish mission in San Ynez, which included the Camp 4 property, and later the Mexican governor granted lands to Chumash members that included the Camp 4 property. The Mission Relief Act of 1891 created a commission which found that the tribe continued to reside in the San Ynez and Camp 4 area, though only 99 acres, mostly unusable creek bed, were ultimately taken into trust. The reservation grew through small additions to about 130 acres today and is home to 17% of tribal members and lineal descendants, lacks any additional space for homes, lacks safe access and escape, especially in emergencies for emergency equipment, and is at the risk of flooding. The Chumash have long worked to provide for the needs of their members without relying upon outside assistance. In the 1960s, the tribe raised funds through a number of creative means to provide the reservation with running water for the first time. In a continuation of this self-sufficiency, the tribe purchased the Camp 4 property in 2010 with the intent of addressing the housing needs of its members and lineal descendants. Unfortunately, the Chumash's efforts to secure housing for their members, efforts which, it must again be noted, are undertaken with the tribe's own resources, have been hindered by anti-growth extremists and frivolous lawsuits. One local anti-group has gone so far as to question the legitimacy of the tribe's federally acknowledged status and its existing reservation, despite records of the tribe's presence in the area dating back over 470 years. Though the tribe has repeatedly attempted to work with the county to reach a mutually agreeable arrangement to address any impact to the local governments, a vocal minority of residents have persuaded the portions of the county government to refuse to even negotiate with the tribe. Some opponents claim that the trust proposal would reduce county property tax revenues, ignoring both the fact that the county currently receives just $83,000 from the property annually and the tribe's initial offer of $1 million each year to offset any impacts to infrastructure or services. Other opposition arguments are equally misleading, claims that the proposal would be too densely developed, which ignores an adjacent housing subdivision, which is actually more dense than the Chumash proposal. Despite this continued mistreatment, the tribe strives to be a good neighbor and support local governments, funding multiple full-time firefighter and paramedic positions, and recently a new ladder fire engine. Again, the Chumash intend only to build housing for their members, and the measure includes a prohibition on gaming in the measure, ensuring that no casino will be built on the property. When did it become acceptable to obstruct the efforts of historically mistreated groups to provide themselves with housing, one of the most fundamental human needs? Prior Congresses and previous presidents have worked to right the generations of wrong committed against American Indians. They would be appalled by the actions of those attempting to prevent the Chumash from meeting the most basic needs of their members on lands that their ancestors occupied for millennia. Additionally, on a very basic level, I firmly believe that any American family should have the right to build a home for their own purpose on land that they own, within reason. Mr. Chairman, members of the subcommittee, the Constitution places great responsibility to address relations with Indian tribes with the Congress. A number of laws require that tribes receive the support of the federal government for education, health care, and housing. Chumash have strived to address these needs with their own resources, an effort that every member of the subcommittee should support. While the BIA has indicated that it intends to take the property into trust administratively, opposition groups have already announced their intent through the courts to obstruct the administrative process indefinitely. It's imperative that Congress act to ensure that the tribe is able to address its needs in a timely fashion, and I urge and appreciate your support of this bill. Thank you. I yield back.
I thank the gentleman. I recognize Mr. Hoffman to make a statement on his legislation.
Thank you very much, Mr. Chairman. I want to start by thanking you and Ranking Member Ruiz for including the Lytton Rancheria Homeland Act of 2015 in today's hearing. I also want to welcome the chairperson of the Lytton Rancheria, Margie Mejia, who is here to speak in support of the bill today. This bill, which I am pleased to introduce with my friend Congressman Jeff Denham, takes lands already owned by the Lytton tribe in Sonoma County into trust for housing and other non-gaming purposes as part of the Lytton Rancheria Reservation. In 1958, this tribe, which was federally recognized as a Pomo Indian tribe, lost its homeland when it was terminated by the federal government. The tribe was restored in 1991 by the courts to federally recognized status, but the restoration did not include restoring the tribe's reservation on its ancestral homeland. Part produce bills that are at odds with my local government colleagues. And so an important condition of my introducing this bill was that the tribe negotiate agreements with its local government neighbors to address and mitigate potential concerns, including the strong opposition to new casinos in Sonoma County. They've done that. The agreements that have been negotiated, and in some cases there are some processes still underway, will provide certainty for all parties and provide a model for functional, respectful, productive relationships between local governments and federally recognized tribes. This bill ensures that the Lytton tribe, after many long years, can finally return to its homeland, can return to a homeland, and it does it in a partnership that works for its local government neighbors. The County of Sonoma and the tribe have entered into a memorandum of agreement on March 10th, 2015, and Mr. Chairman, I ask unanimous consent that the resolution signed by the Sonoma County Board of Supervisors be entered into the record.
Without objection, so ordered.
The chairperson of the Sonoma County Board of Supervisors, Susan Gorin, has also written a statement for the record, and I would ask unanimous consent that that be entered into the record at this time, too.
Without objection, so ordered.
I'd like to highlight just a few lines from Supervisor Gorin's statement. She says the tribe and the county worked together to accurately identify the off-reservation impacts and, as the project changed over time, to build a framework that met the parties' respective interests. Enactment of HR 2538 will reestablish an historic homeland for the tribe in Sonoma County while setting a course for a constructive intergovernmental relationship and addressing community concerns regarding gaming. The town of Windsor is still working through a cooperative process with the tribe, which will include some public proceedings. While that is happening, I am pleased to note that 2 of the affected local agencies in Windsor have already reached agreements with the tribe covering their interests. So the Lytton Rancheria has entered a separate MOU with the Windsor Fire Protection District to provide emergency services to the tribe. I ask unanimous consent that that agreement be entered into the record, Mr. Chairman.
Without objection.
Thank you. And the tribe has entered a memorandum of agreement with the Windsor Unified School District to prepare for and mitigate the increase in school-aged children who would move into the proposed tribal housing. I also ask unanimous consent that that agreement be entered into the record.
You're going to put in a bill. I mean, this is one way to have a long statement.
I am done at that point, but I'm...
Without objection.
Mr. Ruiz is showing you pictures of his children, isn't he?
It's a little more interesting.
I hear you. Lastly, Mr. Chair, I actually do have one more unanimous consent request. It is that we enter the pictures of Mr. Ruiz's children into the record. No, in seriousness, it is that we enter the map referenced in my bill into the record. So.
Without objection.
Thank you. And as evidenced by the documents that I've just referenced, the tribe has worked very hard to reach agreements and address potential concerns from its neighbors and local governments. I'm very thankful for those efforts. An agreement like this that works for all of the affected parties, in my opinion, is far preferable to everyone involved than the black box of the BIA process. And so I am pleased to introduce, along with my colleague Jeff Denham, this bill, and I would like to welcome Chairman Mejia again. We look forward to your testimony.
Mr. Huffman, a little latitude. Thank you for your kind gesture of the bottle of wine, you know, celebrating my newly bride and everything, so thank you. So this guy still does his job, you know, I can tell you right now. He's up there, but thank you.
You're welcome. Congratulations.
Thank you. Mrs. Capps, you're recognized for comment on the legislation that affects your district.
Thank you, Mr. Chairman, for giving me the opportunity to provide a statement on HR 1157 today. I want to congratulate you as well in a personal way, and I also do not have any unanimous consent requests. But I also have 3 constituents who are witnesses today, and I want to welcome them to this hearing. HR 1157 is a bill that would take 1,400 acres of land known as Camp 4 in the San Ynez Valley into trust for the San Ynez Band of Chumash Mission Indians. The San Ynez Valley, which is in my congressional district, has a long history of limited development and has long been a concerted effort, and there has long been a concerted effort to retain the undeveloped rural nature of the valley. As the earliest inhabitants of the valley, the Chumash certainly share the community's commitment to protecting and preserving the land and the unique qualities of this area. I've had the pleasure of working with Chairman Armenta and the tribe on many occasions over the years, including on their wonderful tribal health clinic and education center. It is clear the tribe has legitimate needs for more housing for its members, a need that must be addressed, and that is why I have worked many years to try to bring the tribe, local community members, and county leadership together to work out the differences and find a way forward. While I know this has proven to be a difficult process, I sincerely believe that there can still be, and there is a path forward that meets both the needs of the tribe and addresses the concerns of the county and local residents. But let me be clear, HR 1157 is not that path, and I oppose it for several reasons. First, the issues at the core of this matter are fundamentally local. This is ultimately about local housing, zoning, and land use. These are issues best resolved by county and municipal officials in consultation with local residents and the tribe, not in Washington, D.C. by members of Congress who don't even live near the area. These are issues that have always been worked out locally because they involve very localized knowledge of the community and its residents. No matter how well-intentioned, without the support of the local community, we here in Congress, in my opinion, should not intervene in this local issue. Second, the bill is unnecessary because Camp 4 has already been taken into trust. While I think we can all agree that the BIA fee to trust process certainly has its flaws, This is the process that has been put into place to resolve issues like Camp 4, and that process is moving forward. After roughly a year and a half in review, the BIA approved the tribe's application last year on Christmas Eve. The process may not be moving as fast as the tribe would prefer, but the application was approved in a timely manner, and the appeals will be considered under new rules that expedite the process. Legislative action such as HR 1157 should be for circumstances when the BIA process is clearly failing. This is not one of those circumstances. Third, with the Camp 4 already taken into trust, the only real effect of this bill would be to cut off consideration of the appeals of the BIA decision currently being considered by the Assistant Secretary Kevin Washburn. Again, the BIA appeals process may not move as quickly as the tribe would like, but eliminating the appeals process less than 6 months after it began hardly seems appropriate. Agree or disagree, my constituents have the right to be heard and provide input on this process. This bill would prematurely and needlessly cut off this right. Finally, I am deeply troubled by the precedent being set by the consideration of this bill, and I think my colleagues should be troubled as well. The land taken into trust by HR 1157, as well as the entirety of the Santa Barbara County, is solely within the California's 24th Congressional District, which I happen to represent. The land has no connection to the districts represented by Mr. LaMalfa, by anyone else on this committee, or by any other member of the House. It is my congressional district. I alone have been elected by the people of the 24th District to represent them here in Congress. It's also worth noting that our former Republican colleague, Elton Gallagher, who also represented the San Ynez Valley in Congress for many years, did not support federal legislation on this issue either. I would hope that my colleagues would take a minute to consider this and the door being opened by today's hearing and the committee's consideration of HR 1157. Consider the fact that this committee is moving forward on legislation that is opposed by both local and federal representatives of the communities impacted by this bill. Consider also that the outcome of this legislation could have a profound impact on the future of the San Ynez Valley, yet Valley residents do not have the opportunity to hold the bill's sponsors accountable at the ballot box. I find this profoundly troubling, and I urge my colleagues to consider this carefully. Once again, Mr. Chairman, I strongly oppose H.R. 1157. I urge you not to advance this bill, and I yield back the remainder of my time.
I thank the lady for her statement. Now I'll introduce our witnesses. Mr. Mike Black. Again, Mr. Black, welcome. I'm not going to be mean yet, so just keep that in mind. And then here you're accompanied by Michael Ned, of Energy, Minerals, and Realty Company, and the Honorable now Vincent Armada, Chairman of the Inez Band of Chumash Mission Indians, California, and Miss Mona Masoto, Executive Officer, County of Santa Barbara, on behalf of the County of Santa Barbara Board of Supervisors, Mr. Steve Lafanino, County Supervisor, District Santa Barbara County Board of Supervisors, Santa Maria, California, Mr. Leo Barlow, representative of the community of Wrangell, Alaska, on behalf of the Southeast Alaska Corporation, and the Honorable Miss Mejia, Chairman of the Lytton Rancheria, Santa Rosa, California. And Mr. Black, before we proceed, the committee is still receiving administration testimony now before the hearing. I would suggest you hire a little more efficient clerks, because we, as a committee, do not appreciate 1 hour. The rules are 24 hours at the minimum. I just want you to know that. I've had trouble with every administration in the Department of Interior, just not your administration, not recognizing the rules of the committee, that we have to have the testimony ahead of time so we can review what you're going to say, what you're going to take and defend it or support it, and I think it's inappropriate to have a committee get it an hour before the testimony. That's just want you to know. It doesn't make me happy. So, Mr. Black, you're up. I think all of you know you got 5 minutes, and I will, very frankly, I'm pretty lenient in some cases if you're making sense, and now that's, you got to keep that in mind. So we will try to be as generous as we can and then questions. So, Mr. Black, you're up.
All right. Chairman Young, Ranking Member Ruiz, and members of the subcommittee. I'm accompanied today, as you stated, by Michael Ned, Assistant Director for the Bureau of Land Management. I want to thank you for the opportunity to present the Department of Interior's views on H.R. 1157, a bill to authorize the Secretary of Interior to place certain lands located in the unincorporated area of the County of Santa Barbara, California, into trust for the benefit of the Santa Ynez Band of Chumash Mission Indians. H.R. 2538, a bill taking certain lands located in the County of Sonoma, California, into trust for the benefit of the Lytton Rancheria and for other purposes. And H.R. 2386, the Unrecognized Southeast Alaska Native Communities Recognition and Compensation Act. Taking land into trust is one of the most important functions that the Department undertakes on the behalf of Indian tribes. Homelands are essential to health, safety, welfare, and the welfare of tribal communities. Thus, the administration has made the restoration of tribal homelands a priority and is committed to this effort through the Department's acquisition of land in trust for tribes where appropriate. H.R. 1157 authorizes the Secretary for the Department to place approximately 5 parcels of land into trust for the tribe. H.R. 1157 clearly provides a legal description for the lands that will be held in trust for the tribe, and once the land is placed in trust for the tribe, removes any restrictions on the property pursuant to California state law, but also provides that the legislation does not terminate any right-of-way, right-of-use issued, granted, or permitted prior to the date of the enactment of this legislation. H.R. 1157 also includes a restriction that the tribe may not conduct any gaming activities on any land taken pursuant to this act. The Department supports mandatory fee-to-trust legislation, but takes no position on H.R. 1157, given that the 5 parcels identified in the bill are currently on appeal to the Assistant Secretary for Indian Affairs. H.R. 2538 will place approximately 500 acres of land into trust for the tribe. H.R. 2538 references a map titled Lytton Fee Owned Property to be Taken into Trust, dated May 1, 2015, for the lands that will be held in trust for the tribe. Under H.R. 2538, once the land is in trust for the tribe, valid existing rights, contracts, and management agreements related to the easements or right-of-ways will remain. H.R. 1157 also includes a restriction that the tribe may not conduct any gaming activities on any land taken into trust pursuant to this act. The Department recommends adding language into H.R. 2538 that does allow the BIA to examine the land for any environmental issues prior to such lands going into trust. The Department supports 2538 with some amendments. H.R. 2386 would amend ANCSA to authorize the 5 Southeast Alaska Native communities of Haines, Ketchikan, Petersburg, Tanaki, and Wrangell to organize as urban corporations, entitling each, upon incorporation, to receive 1 township of land, or approximately 23,040 acres, from local areas of historical, cultural, traditional, and economic importance. The bill provides that the establishment of these new urban corporations does not affect any entitlement to land of any Native corporation established before this act being proposed. Although the Department opposes H.R. 2386, we would be glad to work with the sponsor and committees to address issues with the proposed legislation, as well as problems with eligible existing ANCSA communities. Mr. Ned and I would be happy to answer any questions that may have. Thank you again.
Thank you, Mr. Black. We have now, let me see, no. Vincent, you're up.
Good afternoon, Chairman Young, Ranking Member Ruiz, and members of the subcommittee. My name is Vincent Armenton. I'm the tribal chairman for the Santa Ynez Band of Chumash Indians. On behalf of our tribe, first I'd like to thank you today for allowing me to testify on H.R. 1157. The Santa Ynez Band of Chumash Indians is located in the Santa Ynez Reservation in Santa Barbara County, California. Our tribe was federally recognized in 1901 and remains the only federally recognized Chumash tribe in the nation. The Chumash Aboriginal Territory lies along the California coast between Malibu and Paso Robles, as well as the northern Channel Islands. The area was first settled about 13 years ago, and at one time the total population of the Chumash was approximately 18,000. Our tribe was eventually relegated to a 99-acre reservation. For many years, very few tribal members lived on our reservation. Running water, electricity were not available to our residents. We did not even have indoor plumbing until the 1960s. In the 1970s, the tribe was able to secure funding for assistance from the Department of Housing and Urban Development to build the first modern homes on our reservation. Those homes are now nearly 50 years old and insufficient to meet the needs of our people. In many instances, several generations live under one roof. Still, only about 17% of our members and descendants live on our reservation. The HUD homes from the 1970s may have met the basic health and safety standards, but fire and rescue equipment commonly used today would be hard-pressed to service many of these homes. The roads are too narrow, and the population density is too great. Unfortunately, building additional homes on our existing reservation is not possible. The majority of our reservation land is already developed, and the remaining is a creek bed or a sloped hillside. Knowing the housing shortage will only worsen, our tribe purchased 1,400 acres of our ancestral land in 2010, known as Camp 4. Camp 4 just sits a few miles east of our reservation. The Department of Interior has confirmed that Camp 4 is part of our ancestral land. Shortly after purchasing Camp 4, we submitted a draft cooperative agreement to Santa Barbara County Board of Supervisors, hoping to negotiate a payment in lieu of taxes in that agreement. Even though the land was currently only generating $81,000 a year in property taxes, our tribe offered $1 million a year for a period of 10 years. For more than 2 years, the Santa Barbara County Board of Supervisors ignored our offer. On August 20th, 2013, the board voted 3-2 not to enter into a government-to-government dialogue with our tribe, ending any hope we had of resolving this at the local level. The official position of the board to this day is that tribes are not governments, and therefore county need not negotiate with them. One of the supervisors even went as far to call for the end of tribal sovereignty. In spite of the board's decisions, our tribal government continues to build partnerships in our community. For instance, we recently completed a cooperative agreement with both the Sheriff Department and the Santa Barbara County Fire Department. We are paying for law enforcement not just on the reservation, but for the entire valley. And we are providing 2 additional positions at 2 separate fire stations in our community for the purpose of protection of our tribal members as well as community members. These agreements demonstrate that the tribe is willing to work with the county in a positive and constructive manner if we are given the opportunity to do so. Sadly, relations between the tribe and the Board of Supervisors and its anti-tribal allies remain toxic. The board and its allies blocked us from acquiring 6.9 acres of trust land for nearly 14 years. After lawsuits from anti-tribal groups, the BIA finally placed the land in a trust last year. We are willing to work with the county to resolve these concerns. For instance, we address fears of gaming, which is in HR 1157. As witnessed by our lengthy but successful efforts to bring 6.9 acres into trust through the administrative process, we will eventually prevail on this issue. There are only 2 variables, which are timing and restrictions on land use. Mr. Chairman and members, thank you again for the opportunity to testify today.
Thank you, Vincent. Mona Misato?
Yes.
Mona, you're up.
Thank you, Subcommittee Chairman Young, Ranking Member Ruiz, and members of the subcommittee for this opportunity to testify today. My name is Mona Miyasato, and I'm the County Executive Officer for the County of Santa Barbara, California. And this testimony is submitted on behalf of the County of Santa Barbara and reflects the policy position of the Board of Supervisors. The county has adopted a legislative policy that recognizes the role and unique interests of tribes, states, and counties to protect all members of our community and to provide services and infrastructure benefits to all. HR 1157 would take into trust 1,427 acres in the San Ynez Valley, as you've been told, but Camp 4 is over 10 times larger than the existing 138-acre Chumash Reservation, and this would have substantial negative impacts on our community. The County of Santa Barbara respectfully opposes HR 1157 for the following reasons. The county has a pending appeal of the decision by the BIA to accept Camp 4 into trust. The purpose of the administrative appeal process is to address concerns of local entities and residents. These concerns include loss of tax revenue, lack of compliance with NEPA, insufficient environmental mitigations, and conflicts with local land use regulations. HR 1157 would essentially shortcut this administrative process and prevent the county and its residents from addressing these concerns. And finally, HR 1157 does not rule out any use of the property other than gaming, while the BIA's administrative process proposes residential use and has been more focused. Therefore, the County of Santa Barbara requests that instead of enacting H.R. 1157, Congress allow its regular administrative process on the appeal to proceed. And I'd like to spend a few minutes now to detail some of the areas of concern we have. The County of Santa Barbara submitted a timely appeal of the Christmas Eve, December 24th, 2014 BIA decision to accept Camp 4 into trust. In the appeal, the county thoroughly discusses the process shortcomings, including the need for appropriate weighing factors detailed in the Code of Federal Regulations, as well as a lack of adequate environmental review, including the need for an environmental impact statement rather than the environmental assessment and appropriate mitigation. This bill would bypass that appeal review. Also, the county questions the need for and purpose to take the land into trust, as the present BIA regulations provide inadequate guidance as to what constitutes legitimate tribal need for a trust land acquisition. Given the stated need for only a fraction of the acreage requested to be taken into trust for housing, the county questions why the 1,400 acres needs to be taken into trust at this time. In addition, the county projected that it would lose up to $311 million in tax revenue over a 50-year period if the land is taken into trust and developed. The county provides major public services to the Camp 4 area, including law enforcement, fire protection, emergency medical response, roadway access and maintenance, and there will be no property tax compensation or funding offset required by the county for these services if Camp 4 is taken into trust into perpetuity. Also, this permanently exempts it from community land use processes. The project alternatives, including a proposal for 143 residents and over 12,000 square feet of tribal facility with parking for 250 cars and possibly up to 800 visitors a week to the valley, is inconsistent with the surrounding uses. The development contravenes rural area policy countywide and is incompatible with the county's general plan, Santa Ynez community plan, and our land use regulations. Further, the property has been preserved for agricultural use by an Ag Preserve contract, a Williamson Act contract, since 1971. In August of 2013, the tribe submitted an application for non-renewal, meaning it will expire in December 2022. Another primary area of concern relates to environmental impacts, such as groundwater resources. Santa Barbara County and the rest of California are in severe drought conditions. The environmental assessment acknowledged the past designation of an overdraft in the groundwater basin in which Camp 4 resides, but did not analyze the potential for Camp 4 to exacerbate that overdraft. The environmental document did not analyze the long-term water supply. Finally, the county supports the BIA's administrative process, although we believe there should be efforts to reform that process. We strongly support the efforts of the California State Association of Counties to achieve comprehensive fee-to-trust reform and improve the role of local government in this process. In conclusion, I respectfully urge members to reject H.R. 1157. As stated, this would bypass the administrative appeal process, whose purpose is to address concerns of our local residents and local entities, and those concerns include loss of tax revenue, lack of compliance with NEPA, insufficient environmental mitigation, and conflicts with our local land use regulations in perpetuity. Furthermore, I respectfully request that reforms to the existing process be considered in the future to improve local government involvement, which can reduce significant impacts on communities and reduce controversy, delay, and existing distrust in the process. Thank you very much for considering my testimony this morning and allowing me to appear before you today. Thank you.
Thank you. Steve Lavanino, is that good enough?
Very good, Chairman Young.
All right, thank you.
Appreciate it. Chairman Young, Mr. Ranking Member, I'm Steve Lavanino, 5th District Supervisor for Santa Barbara County. Members of the committee, good morning. Thank you for the opportunity to speak before you today regarding 1157. The vehicle would move 1,400 acres, known as Camp 4, into federal trust for the Santa Ynez Band of Chumash Indians. In my opinion, I should not be needed here today, and this piece of legislation should have never been necessary. But I believe the Santa Barbara County Board of Supervisors has failed to perform its responsibilities as the local jurisdiction, and I'm grateful you've allowed me the opportunity to provide another perspective. More than 4 years ago, Tribal Chairman Vincent Armenta requested the County of Santa Barbara enter into government-to-government dialogue to discuss the tribe's plans for Camp 4, as well as mitigation strategies for those impacts deemed significant enough to warrant mitigation. On August 20th, 2013, our board held a hearing during which Chairman Armenta once again reiterated his desires to begin negotiations. In order to show his good faith, he made an initial $10 million offer over 10 years for payments in lieu of property taxes, as well as an offer to waive the tribe's sovereign immunity, which would allow the county to legally enforce the agreement. Instead of responding to the offer, our board decided the tribe was not equal to other governments we commonly negotiate with, including our local cities, Vandenberg Air Force Base, and the University of California, Santa Barbara. On a 3-2 vote, the decision was made to reject the request for dialogue. Some would consider Santa Barbara County a progressive region, and it's a leader when it comes to protecting most human rights, but for some reason those same protections are not always afforded to the tribe. During our public hearings, seemingly educated people still regularly question the heritage of the tribal members and the validity of the tribe's sovereign status. While you may expect such comments sometimes from the public, most alarming are shocking statements from current and former elected officials. The county supervisor who formerly represented the area in which both Camp 4 and the tribe's current reservation lie said, quote, "These are not real sophisticated people," unquote. She went on to question their work ethic by stating that they, quote, "get $300,000 a year for sitting on the couch watching a Lakers game," unquote. One of our current board members, whose district is home to more than 800 people employed by the tribe, recently questioned whether or not the reservation system as a whole should be abolished. This is the environment in which the tribe is asked to live and work. I share my colleagues' concerns regarding loss of property tax revenue and loss of local land use control. However, they have refused to even discuss these matters with the tribe. I warned my colleagues that if we fail to acknowledge the tribe as a federally recognized government entity, it would lead to congressional action such as HR 1157. That warning fell on deaf ears. But it wasn't just my advice. Governor Jerry Brown's expert on tribal relations indicated the best strategy for counties in dealing with fee to trust applications is to, quote, "negotiate early in the process." Opponents will speak about density, even though the tribe's plan calls for less density than the neighboring development. They will speak about a lack of water, even though the tribe has proposed a water-neutral development. And they will claim that SEQA will be ignored, even though any development will fall under the regulations provided in NEPA. Although they will claim to be concerned about all of these potential impacts, one has to question what their true motivation is. Just last year, 6.9 acres of land directly adjacent to the existing reservation and slated for construction of a cultural center and park was finally taken into trust after more than 14 years of appeals by these same opponents. Finally, the tribe currently resides in substandard housing that lies directly in a floodplain. In case of a fire emergency, the ingress and egress for those living on the reservation is extremely limited. The tribe purchased Camp 4 specifically to remedy the housing situation and is willing to negotiate with the county to resolve the concerns that have been raised. Without negotiations, the county is destined to incur all of the impacts without any share of the revenue. Unlike some in Santa Barbara County, I understand that the process of taking land into trust is wholly a federal decision, whether it's through Congress or the Bureau of Indian Affairs. Given that fact, my goal is to work together with the tribe to mitigate potential impacts through negotiation. Unfortunately, I believe the tribe has thoroughly exhausted all avenues in search of reaching an agreement with their local government, and thus I understand why congressional action is being taken. Thank you.
Thank you, sir. Now we have Mr. Barlow. Mr. Barlow, thank you and welcome from, I believe, from the great state of Alaska, come down and see me. An issue has been on my burner for a long time, and I wish my colleagues will listen to this testimony and why we think it's justifiable, regardless of what the department says. So, Mr. Barlow, you're up.
Thank you, Mr. Chairman. Good morning, Chairman Young and subcommittee members.
Turn the mic on.
Close. Good morning, Chairman Young and subcommittee members. I've traveled here today from Alaska to provide testimony regarding HR 2386, a bill to provide for the recognition of 5 communities in southeast Alaska in the Alaska Native Claims Settlement Act, commonly known as ANCSA. Thank you for this opportunity to testify on this important issue to several thousand Alaska Natives, and a special thank you, Congressman Young, for introducing this much-needed legislation and for once again taking on our worthy cause. My name is Leo Barlow, and I have the great honor and responsibility of serving as a representative for the community of Wrangell on the Southeast Alaska Landless Corporation Board of Directors, which represents Alaska Natives enrolled through ANCSA to the native villages of Haines, Ketchikan, Petersburg, Tenakee, and Wrangell. The people I represent today have suffered an injustice for more than 40 years, an injustice the legislation currently before this subcommittee would address. In 1971, Congress enacted ANCSA to recognize and settle the aboriginal claims of the Alaska Natives to their traditional homelands. ANCSA provided for establishment of Native corporations to receive and manage funds and lands throughout Alaska and Southeast Alaska. Were recognized and afforded the opportunity to establish village or urban corporations and secure a native land settlement Our 5 communities were denied these benefits of ANCSA, and we have been fighting this injustice since the passage of the Act. Under ANCSA, as Alaska Natives, we enrolled to one of 13 regional corporations and also to the villages where we lived or to which we had a historic, cultural, or familial tie. For example, I enrolled to the region for Southeast Alaska and also to the village of Wrangell, my hometown, where our ancestors have lived for many generations. A total of 747 Alaska Natives enrolled to the native village of Wrangell. Other members of our landless corporation enrolled to the 4 villages of Haines, Petersburg, Tenakee, and Ketchikan. Those of us who enrolled to these 5 communities during the ANCSA process did so because they are our traditional homelands and places of origin. Our families and clans originated in these communities and have lived here for hundreds, if not thousands of years. In Section 11 of ANCSA, Congress set forth a general process for determining eligibility for each native village in Alaska. Native villages throughout the state of Alaska were listed in this section, and the Secretary of the Interior was charged with making determinations as to whether the listed villages met the eligibility requirements. For a number of reasons, however, there was a different process created for determining eligibility of Southeast Alaska Native villages in Section 16 of ANCSA. These reasons included previous Tlingit and Haida Indian claims cash settlement, the existence of the Tongass National Forest, the existence of large timber contracts secured by powerful pulp companies, and the significant non-native populations of certain communities. Another significant difference between Southeast and non-Southeast Alaska communities in ANCSA was the fact that Section 11 of ANCSA provided an appeal right for communities left off of the list of eligible villages, while Section 16 of the Act did not. 3 of our coalition's villages, Ketchikan, Haines, and Tenakee, brought protests of this inequitable treatment to the Alaska Native Claims Appeal Board of the United States Department of the Interior through appeals in 1974 and 1977. The appeals were rejected because Section 16 made no provision for the administrative reconsideration of the eligibility of villages in Southeast Alaska. Thus, we must appeal directly to Congress for help. You are our only recourse. The over 3,500 natives who originally enrolled to the affected 5 villages comprised over 20% of the shareholders of Sea Alaska Corporation in 1972, our regional corporation. Over the years, we have received revenue sharing distributions from Sea Alaska pursuant to Section 7J of ANCSA, but have not enjoyed the social, economic, and cultural benefits of owning shares in a village, urban, or group corporation. Many of the village or urban corporations in our region have brought significant economic benefits to their communities. Additionally, we have been deprived of the significant cultural benefit of owning an interest in lands located within and around our traditional homelands. The history I am telling today is not based only on the opinions and conclusions made by landless natives. In 1993, the Congress directed the Secretary of the Interior to prepare a report examining the reasons why the unrecognized communities have been denied eligibility to form native corporations under the Act. This report, a study of the 5 Southeast Alaska communities, referred to as the ISA report, was done by the University of Alaska, concluded that requirements for villages eligible to form native corporations were met by the native villages of Haines, Ketchikan, Petersburg, Tenakee, and Wrangell. The report noted that our communities appeared on early versions of native village lists in the ANCSA Act, and the subsequent omission was never clearly explained in any provision of ANCSA or in the accompanying conference report. The ISA report is attached here too, and I ask that the subcommittee incorporate this report into the record for this hearing.
Mr. Barlow, how much time do you have left?
I'll conclude fairly rapidly here, sir.
Okay. You're finished?
Okay. Almost.
Okay.
The legislation before this subcommittee today proposes simply to correct a 40-year wrong and grant rights that we, the native communities of Haines, Ketchikan, Petersburg, Tenakee, and Wrangell, should have been given in 1971. Unlike other native villages that were recognized under ANCSA, our communities have not been able to use the tools provided by the Act to create an economic engine by utilizing the resources of our lands and to promote the well-being of our community members. Sadly, many of our elders have passed who fought for this legislation. We have seen a generational change, and we have much interest now by our younger shareholders who will carry on this battle. In closing, Mr. Chairman and members of the subcommittee, on behalf of the Southeast Alaska communities affected, I want to once again personally express our extreme gratitude for your consideration of this important legislation. With that, we conclude our report, and thank you in our language, Gunushchish Hawa Daksin.
Thank you. The next witness is the Margie.
Yes. Good morning, Chairman Young, Ranking Member Reese, and members of the Subcommittee on Indian, Insular, and Alaskan Native Affairs. My name is Margie Mejia. I'm the chairwoman of the Lytton Rancheria in Santa Rosa, California. Thank you for allowing me to be here today to speak in strong support of HR 2538, the Lytton Rancheria Homeland Act of 2015. A special thank you to our Congressman Jared Huffman for working with the tribe to introduce the bill, and our neighboring Congressman Jeff Denham for supporting us and co-sponsoring the bill. The tribe has provided a written statement for the record, and I would like to explain why the passage of this bill is so important for the Lytton Rancheria. Taking this land into trust will allow the tribe to construct with its own funds housing and community facilities. This will allow the tribe to live as a community for the first time in over 50 years. The creation of a homeland will allow the tribe to govern itself and continue to diversify its economy to provide for tribal generations to come. The status as a federally recognized tribe will fully be restored, and the tribe will now be on equal footing with other recognized tribes. Thank you for your time and your support, and I am available for any questions you may have. Thank you.
Thank you. And before I recognize the ranking member who will ask the first series of questions, Steve, I will tell you, this is not new to me. This issue has been around for a long time, and thank you for your testimony. I mean that because I have not seen the effort put forth, as you suggest in your testimony, by the people involved that don't want the bill to pass. If I thought for a moment there was true negotiation, government to government, I wouldn't be having this bill. I wouldn't have this hearing. But I don't see that effort. I see a total lack of consideration. And some of the comments you made are telling about the character of some people. And so we're going to try to move this piece of legislation. With that, I'll recognize the ranking member.
I'm going to go ahead and yield the first round of questions to Representative Huffman. Go ahead.
I thank the ranking member. My question is to Mr. Black from the BIA. One of the reasons I introduced this bill is that I appreciate the detailed agreements that this tribe, the Lytton tribe, has reached with county and local agencies. These are agreements that anticipate and mitigate possible impacts. They describe how future decisions will be made. And along with the legislation, they actually prohibit gaming on the land. Now, it's my impression that if we think about the alternative of the BIA process, there are far fewer opportunities for all of the affected parties to collaborate on a path forward. Can you give us an idea as to how many applications the BIA has approved in recent years, including post-carcieri, and how much land has been taken into trust through that process?
Yes, sir. Thank you for the question. We've brought in, since about 2009, we've brought in approximately 1,921 applications totaling a little over 300,000 acres of land into trust for tribes.
So the perception that carcieri sort of shut down the BIA land to trust process is incorrect. We hear this sometimes.
Yeah. No, I wouldn't say it shut down the process. It did add some complications and length to the process, yes.
Right. As we heard from the chairperson of the tribe, the Lytton Rancheria is a federally recognized Pomo Indian tribe, and these folks have occupied land in California and entered into treaties with the federal government going back to the 1850s. I understand that the tribe has 2 land to trust applications pending before the BIA, and I wonder if you could speak to the scenario where if BIA approved those pending applications, would any of the agreements that have been reached with local agencies or the county or the prohibition on casinos, would any of that necessarily be included in a BIA decision on those applications?
Those decisions, or those types of agreements and stuff, are considered when we're reviewing applications, but they do not become part of the application process or the decision, no.
So there would be no guarantee, for example, that there would be a no casino provision in a BIA decision?
No, generally not, no.
Chairperson Mejia, your written testimony explains that you've used revenues from San Pablo, the casino, to buy lands in Sonoma County from willing sellers. And some of the property that the tribe has acquired includes vineyards. The tribe is now getting into the wine business. Why is it important for you that the tribe diversify its economic holdings?
It's important because you can't put all your eggs in one basket, and gaming, while it's a viable vehicle for generating revenue, we can't be guaranteed that that's going to always be there. As a senator told me years ago, the gaming industry is fluid. Secondly, it's what IGRA intended, for tribes to be sovereign, and you diversify to make your money work for you, and to be able, for the longevity of the tribe, to provide for my members for generations to come, and not only for my members, but for the community, because with the agreements that we have, we are definitely good neighbors. And I think the signed agreements show that.
You have agreements with the County of Sonoma, the local fire district, local school district, the possibility of an additional agreement with the town of Windsor. This is a lot of work. You're not required by law to do any of this. Why was it important to you to spend months, and actually I think even years, at the negotiating table to try to work these things out with your local government partners?
It was important because we want to be good neighbors. We don't want to be in a community where we're not wanted, and we are a burden. So in doing these agreements, we gave the local communities the assurance that we were going to be good neighbors, we were going to be productive citizens in the community, and it's a mutual respect and a win-win situation for everyone.
Well, I want to thank you for taking that approach. This is not how it always works in these land-to-trust situations around the country, or even everywhere in my district. So I applaud you for doing the hard work of trying to work things out with your local government partners, and appreciate your testimony today. With that, I yield back.
Thank you. I'll yield myself 5 minutes, since I was up next. Ms. Miyasato, you work for the county board, then, or the board of supervisors, then, right? You're the executive director. And I listened to your testimony and why you oppose the land of the trust thing and the reasons for it. I guess the question I have for you is, how do you propose remedying the tribe's current need for housing?
Congressman, thank you for asking that question. We never said the tribe didn't need housing, and when the board made its decision back in August 2013, which Chairman Armenta and Mr. Lavanino referred to, the actual motion was for the tribe we requested that they begin discussions with the county regarding their plans to develop housing on Camp 4 and other projects that they'd like to see, and they directed their staff, us, to work with the tribe on any potential plans for Camp 4. So I just want to clarify that was actually the board's direction to staff, and there was a meeting, I believe, with a representative from the tribe and with our staff, and there was an explanation of our process and no follow-up from the tribe.
Well, what about the gentleman next to you? Both stated that the county was unwilling to work with the tribe as a government. What's that about?
Congressman, I think that since I've been with the county, I've been with the county for a year and a half as a CEO, and I know there's been different stories and discussions about what had happened, and so I went back to look at the record myself. And all I can tell you is that the actual direction from the Board of Supervisors at that time and at that meeting was directing staff to work with the tribe in discussions with our planning staff on plans to develop Camp 4. And that's the information that I have. And since I've been with the county, the Board of Supervisors has worked productively with the tribe. There are two agreements that Chairman Armenta discussed, which was one for sheriff services and fire services. So they offered, and the county voted unanimously to work with them and approve those agreements. And just as a side note, those agreements for existing services on the reservation.
Chairman Armenta, now, give me your response to what she just said here. You know, what's the story? I mean, like any other landowner, can't you do an application to, you know, put up housing, and why is this not an option for you?
Our request at that meeting was that the county meet and negotiate with the tribe on a government-to-government basis. Instead, the County Board of Supervisors failed to acknowledge our sovereign status and pointed us in the direction of staff, county staff, as a typical landowner, not as a government. That's the direction we were sent down.
So that's not going to work for you then? Is that the story?
To address the housing needs for our membership, that does not fall within the Santa Barbara County or the San Ynez Valley Community Land Use Plan, no, sir.
I see. So that you couldn't build housing there without it being put into trust?
We could build one house for every 100 acres. So we could build 14 houses.
I see. Okay, let me ask Mr. Barlow, can you discuss a little bit further the economic benefits that the recognized tribal communities in your area might have with the passage of this?
Thank you for your question, Congressman.
I mean, you mentioned it, but I need a little more detail.
Sure. In the case of those communities in our region that have been recognized, they have been able to form business operations. We're organized under a corporate structure in Alaska. And they are into several different enterprises, including things such as government contracting, including ecotourism, cultural tourism. Some have invested in operating companies all over the United States of America. This has allowed them to, provided they are profitable, have enough wherewithal to fund such things as cultural programs, educational programs, scholarship programs for their share owners, as well as to participate in furthering the political process in the region. So they have much more of a realized benefit than those of us who have not been recognized.
All right. Thank you. I appreciate it. I just want to ask Chairwoman May a question here. Can you describe the current status of the land again to me that's going to be taken into trust? What's the current status?
It's held in fee.
Oh, okay. All right.
It's owned by the tribe, but it's in fee status currently.
Okay. All right. Thank you. Yield back.
Mr. Ruiz.
Thank you, Mr. Chairman. Mr. Black, I have a clarifying question. I heard today that the Chumash bill is unnecessary because the land is already into trust. The Camp 4 land is already into trust. Is it into trust?
The decision was made by the Pacific Regional Director to bring that land into trust. That decision is currently under appeal. So it hasn't completed the process, no, sir.
Okay. So it is not into trust?
Not officially, no. It's still under appeal.
Chairman Armenta, I understand that in the late 1800s, the tribe lost over 13,000 acres of land. It seems to me that one of the concerns was that this new land would be 10 times larger than the existing reservation, but yet you lost your ancestral land that was larger than this 10 times the size of what your current exists. Can you give me more of that history, please?
There was a lawsuit filed by the Archdiocese of the Catholic Church against the federal government to remove the tribes and the tribal members' name off a title. When the Catholic Church held that land with the tribe on title, and in return for that lawsuit, that's when they gave us 99 acres. For a period of time, we were on title for over 13,000 acres.
So you had 13,000 acres. They put 99 acres, put you on 99 acres, and of those 99 acres, how many of it can you develop housing on or do anything with it?
The original 99 acres, about 40 acres of it is developable.
So in other words, they took away your land, put you in a very small piece, and the majority of that are rocky hillside where you can't do anything with it. Is that
Either rocky hillside, sir, or swamp.
okay? And so my understanding is that you own this piece of land, and it's been determined to be your ancestral land, and you want members of your tribe to come home to basically live on their land. Is that the premise of this bill?
Yes, sir, it is.
Okay. And my understanding from what I've heard today is that you have shared any concerns, the burden of any concerns in providing for law enforcement, fire department, and anything else that the local different agencies want you to address. But that the stalemate here is that the county does not want to negotiate in a government-to-government level with the tribe. Is that my understanding?
That is your understanding. We currently have 2 agreements with Santa Barbara County to provide law enforcement and fire safety of a total of about $2 million a year.
So I'm wondering, what is the heart of this issue? So they're concerned about gaming, and you put in the provision there's no gaming. They're concerned about taxes, yet you want to give them $1 million a year when they're only collecting $81,000. So that's 125 years worth of taxes in the next 10 years. You are going through the NEPA process. You're looking at water. There's a development next to yours that's even more dense in housing than what you're proposing. So this question is for Ms. Miyasato. What else? What's the heart of this issue? What is the real? What's the matter here?
Congressman, there's a couple of different things that you've mentioned, so thank you for mentioning those things. One is when you talked about the provision of service. So the provision of service that Chairman Armenta discussed is for their existing reservation in the casino, and we considered it as mitigation for those. And their casino expansion, which is a recent project to put in a 12-story tower in their to expand their casino with that. And so the recent agreements we've agreed to with the chairman and the tribe were really for the existing reservation, not for the 1,400 acres that we're talking about today. In addition, you talked about, and rightfully so, you said there's other land in the area that's developed. When the community went through a community planning process and the county went through a comprehensive planning process, we said, yeah, we agree. There are some pockets of development, but those are not pockets of development we would like to see in this particular land, which has been zoned for agricultural use. And as Mr. Armenta said, it's zoned for 100 acres. And it's because when we went through this local community planning process, we said there are areas that are part of the urban boundary and areas outside. And we in Santa Barbara County are committed to preserving and encouraging agricultural viability. And so some of the land that's been purchased by the tribe is in that agricultural zone. And so it's really a discussion of the community's values of maintaining agricultural use and confirming the community's desires through our comprehensive planning process. And then this land being in there, this isn't infill development. We're talking about an area that we've looked at for rural agricultural use. And when the chairman said that he couldn't build the house...
So then, in other words, the point of the matter is that you don't want housing on this agricultural, because it seems to me that everything else, the tribe is bending over backwards to work with you. And so then it not only becomes an agricultural zoning issue versus whether you want to build houses on it, but on the flip side, the other side of the story is a moral justification for some sense of justice for a tribe who's lost a large portion of their land and is now simply wanting to have their members to come home and to have a homeland of which it was taken away years ago. So that is, I believe that's sort of the dilemma that's going on in this. And one of the things that I want to make very clear is that they are a government. They are a sovereign nation. And for any institution in the United States not to recognize that is backwards. And so we need to make sure that they're respected, that they have a seat at the table, and that they are in negotiations with any other government as a government. And I believe that is another heart of the matter for our committee to make it understood to the county.
I thank the gentleman. That's Mr. Malalfa.
Thank you again, Mr. Chairman, and again, thank you all for your travel here to come all the way to D.C. Chairman and Supervisor Ms. Miyasato, sorry about that. Supervisor, I think we may share the same old country roots, so I'm going to try it the right way. Is it Lavianino? Lavianino. Okay, all right. Trying to account for the G there, so anyway. Now, as a county supervisor, and you know, I represent 11 counties up in the north in the 1st Congressional District, and it's pretty rural. So they're always battling, trying to stay funded, trying to work with the federal government for a lot of the federal lands that are owned there, that we have the PILT, payment in lieu of taxes, and that's probably fairly important to you in Santa Barbara as well. So what we're looking at here is kind of a PILT type situation. Of course, there's concerns taking land into trust, but we've seen where the Chumash tribe has stepped forward to more than make up for that. So what do you see that as being beneficial for your county, which I would imagine all counties, you know, having worked with CSAC and RCRC before, how important is that to you to see the potential benefit here?
Thank you, Congressman. You know, we've, as any county has over the past few years in California, we've struggled financially, and this was our first year where we really had a surplus, and we've been able to restock our surplus accounts. But obviously, when you're talking about an area, if you're just looking at this from a financial perspective, we've been receiving somewhere between $80,000 and $85,000 a year, and now we'd be getting $1 million a year. Obviously, that would have a significant impact to the services that we provide.
And earlier, Chairman Armenta testified that they do indeed provide not only their own weight, but above that with their emergency services and other things they provide to the area, to the valley. So that has to have a pretty positive impact already as well for you.
It does, and it's very well received, and those were actually agreements that the chairman worked. I would have to say it's almost offline with the sheriff. The Board of Supervisors was not involved until we actually approved the contracts at the end. They brought us the contracts of between the tribe and the sheriff and the tribe and our fire department. And one of them is for a large, forgot how much they spent, over $1 million on a piece of equipment that's going to be used all throughout the San Ynez Valley.
Okay, thank you. Ms. Miyasato, you kind of mentioned earlier that the legislation or the effort by the tribe would be a shortcut to getting to their end goal of providing housing, of using their land as they would perhaps like to see fit. So they've already owned the land for about 5 years, but even more so, you point back to the taking into trust recently 6 acres adjacent right to their the trust land they have, which was a 14-year lawsuit-filled process. How can you really think that at this point this looks like a shortcut when they've waited this long and past history shows that they have endured a lot of unnecessary attorney's fees and delay? Again, with the end goal, they have members that need housing, would like it in a traditional way with people they would like to associate with. How can you justify that?
Congressman, I think what we're saying in the county is that you have a process, Congress has a process for hearing the community and the local residents' concern through the appeal process, and we'd like to see that through rather than have this bill preempt that. And on the 6.9 acres, you know, I'm sympathetic to the tribe and the length of time, and I just want people to know that the county did not oppose that taking that into trust. And it was commercial property for their uses, and we did not oppose that. I think the issue here again is that...
But you have a culture there of people that will come forward with lawsuits, frivolous in nature, and that's debatable, I suppose, but the delay there for people trying to do what they see fit and do business, and the county is contributing to that in this scenario here.
Congressman, I think that there are some errant voices and maybe misguided voices in the community, as you've pointed out. In my time there, in evaluating that and talking to community members, I think the main concern is just the change in use and the lack of input through the process. And as we talked about,
Been plenty of input through the courts, ma'am, and it looks like there'd be more to come along. And a disturbing thing, too, is that you didn't acknowledge that they are already providing emergency services above and beyond what anybody would expect. Instead, you referred that the county has to do this on the lands that are as is. And so I think a little more acknowledgement of the cooperation of the tribe, it would be very much in order. I'll yield back, Mr. Chairman.
Thank you. Ms. Torres?
Thank you, Mr. Chairman. Just a follow-up question to Ms. Miyasato. What are you were talking about community values. I happen to value affordable housing. Have you met your RENA numbers?
For this state, yes, we did. Yes, we have. We just passed our most recent housing community development plan for the state of California. So we just approved that, yes.
Okay. What is the number of homeless individuals in your county?
Congressman, I don't have that information, but I could certainly provide it to you.
And when you provide that information, would you provide tribal members that may be homeless or at risk of homelessness? Chairman Armenta, can you give the committee a little bit of more information about the tribe's current housing stock? Specifically, can you elaborate on who does and doesn't live on the reservation?
Yes, Congresswoman. Currently, we have 65 homes on the reservation. There are 143 enrolled tribal members, or 500 children. Of those, 17% live on the reservation. They are homes that were started being built in the 1970s by HUD. Most of them 2, perhaps 3-bedroom homes that are housing multiple generations.
And as a follow-up, if the tribe is able to acquire this land, how far would it go towards addressing the housing situation among tribal members?
It would assure that every enrolled tribal member would have a home to live in on the reservation and practice our cultural beliefs as well.
And I read in the reports about all of your outreach efforts to the community. Can you elaborate for this hearing today how extensive those efforts have been?
Congresswoman, we have lived within this community far before it was developed. Even when the first settlers came in, we felt that it was the responsibility of our tribe, it was the nature of our membership, to be hospitable to people. We provide our community, I believe, with items that are not recognized as well as they should be. For instance, the fire agreement. This fire agreement that we have with the county was originally dated back to 2002, that I personally negotiated far before any casino expansion. 3 years ago, I started negotiations with the county sheriff, well before we were doing any expansion of any casino. California is a public law 280 state. Santa Barbara County has a responsibility for providing fire service and public safety law enforcement on reservations. We just insist on helping them because we know it not only makes our reservation community a better place to live, but it makes the San Ynez Valley a better place to live.
Right. Thank you. Thank you, Mr. Chairman.
I thank you, gentlemen. Mr. Gozar.
Thank you very much. Director Black, the tribe has been very forthcoming that this land taken in trust will not facilitate a casino. Is that true?
Yes, sir. The legislation has that statement in it.
So they've been above board the whole time?
That's my understanding, sir.
Well, the reason I bring that up is that we have a problem in Arizona that a tribe wasn't very forthcoming, actually lied to the commission in Arizona in regards to providing or buying a piece of property and extending gaming casinos in Phoenix. So that's very important that they were straightforward. Chairman Armento, you've been very forthcoming as well. You've been more than polite, extending a hand. Is that true?
Yes, sir.
So do you see this as a win-win situation, the potential for a win-win situation?
I believe anytime two governments work together, it's absolutely a win-win for both parties involved.
Ms. Sato, I may probably saying your name wrong, I'm sorry. Do you see a position for a win-win situation in this?
Congressman, I think there's always a chance for a win-win opportunity.
I don't know, I don't like that word chance, because it seems to me like you're on the back burner and they should be on the front burner. So tell me that there's a win-win situation here, because I'm about ready to tell you about how it can happen.
I think there can always be a win-win situation, and
particularly when you have that mindset, right? When you go in with a positive mindset, there's a lot of things that usually
there's
happen.
a lot you can do with a positive mindset. You're absolutely right, Congressman.
Yeah. Well, I see a lot of negativity in this process. I have a tribe in my hometown. It's called the Yavapai Apaches. And what happens is they have an island, and they're surrounded by the town of Prescott and Prescott Valley. And so a choice came to this entity about collaborating and working with the tribes or trading like what you're doing right now. And it's turned out to be a magical relationship, because when there's a problem for Prescott and Prescott Valley with the federal government, they take and let the tribes address it. That's unbelievable. And then when they have the state and local aspects, the city councils and the board of supervisors work. They even include them in their economic plan. Yeah, they have a casino up on top of the hill, but they're very diversified in their applications now. Why don't we see something like that in this case?
Congressman, I think that, and again, I'm going to give from my experience, is that the relationship has been inconsistent with the tribe and the county. So
And whose fault is that?
I think there's shared responsibility in that. And I think Chairman Armenta talked about the great things that they've done for the county, the sheriff agreement, the fire agreement. And again, that was a response to their existing reservation and their existing casino. And the fire truck that he mentioned, that was brought up by our fire staff, not brought up originally by the tribe, to provide an aerial fire truck to service a tower that's part of the casino expansion. And our staff is the one who brought that up. That wasn't part of the original plans or the mitigation. And the things that we wanted to continue to talk about, we asked the tribe, that's great, and can we continue talking about these other things that we see as issues? They never came back to us. So I think it's an uneven discussion.
So let me ask you a question. It seems like, from your standpoint, from I do the background on this, is you've delayed and delayed and delayed and delayed from the county's perspective. Would you agree with that?
From my existing experience, I don't see that we've delayed and delayed.
Chairman Armenta, would you agree or disagree with that comment?
I would have to agree with it, sir.
Okay. So how do you go forward? I mean, you want us to slow this legislation down, and I don't think the Congress wants to do that, because that's our jurisdiction. So how do you see the next time frame of the next, let's say, 6 months?
Congressman, we would like the appeal to proceed and have those discussions about the issues that we do see with the process and with the fee to trust application and some of the inadequacies that we saw in the environmental impact or the environmental assessment, some of the issues that we saw need to be addressed that weren't addressed. So we would like that process to proceed so that we, the county, the government, and the local communities can have some more input in discussing those impacts and what we see our issues.
Chairman Armenta, how do you see the next 6 months?
Congressman, I have not seen a change since 1999 when I became tribal chairman. I have reached out to the county many times. I will continue to reach out to the county, but to be perfectly honest, I don't know if the county is going to allow that. So I don't know if I see much change. If there's an opportunity to meet with the county, I will absolutely do that.
I see a possibility here that Congress needs to keep the fire on you guys' feet. Now, I've done this with the Forest Service in our fire-laden forests in Arizona. So I actually would applaud the folks here to continue pushing this legislation. And I ask you to speed up your negotiation and do it in good faith, because there's a win-win at the end of this tunnel. So thank you very much, Mr. Chairman.
I thank you, gentlemen. Mr. Denham? No.
Thank you, Mr. Chairman. Ms. Mayasota, In our notes here, it says that you're currently getting $82,000 annual for tax revenue on that current piece of property,
That's correct, sir.
and the tribe is offering $1 million. Those are correct numbers?
I'm told the tribe offered $1 million some time ago.
And in this relationship, this government-to-government relationship, this negotiation that you're having with the tribe, what is it you're actually looking for? What are you asking for?
The last action of the Board of Supervisors was to ask the tribe to engage us in a planning process for their housing development and other uses that they asked for on the site.
Other uses, so you want a greater say over the agriculture part of the land use?
We wanted a greater say into the whole development, so there was part of the application or part of the initial project alternatives from the tribe was, one was to have lots of open space, one was to do a community facility, an exhibition hall, and have sort of visitor serving kind of uses.
Do you not want an exhibition hall or another type of facility there?
Currently, we believe that would have significant impacts to the residents if it brought 800 visitors to the valley. And so we wanted to have more discussions with the
What
tribe
impact
about
would it
that.
have?
Well, one could be traffic, one could be noise, one could be the intersection with the agricultural area. We have these agricultural buffer areas between commercial or
It's
residential
currently
areas.
in ag use
uses.
now, is it not?
It currently is, yes, sir.
Okay, so further ag use is not a problem, is it?
Further ag use is not a problem currently.
Okay, and the density of this housing development is less dense than the current housing unit that is adjacent to this property, is it not?
Congressman, could you repeat that?
There's another piece of property adjacent to this property where there's a housing development that is more dense than what is actually being proposed by the tribe.
There's a housing development that's one unit per 5 acres to the east, and that was one of the things that the tribe had proposed would be a 5-acre
I
project.
guess what I've continued to not understand over the years, and I think the committee members of this committee are failing to understand, is if the housing development is less dense than the one next to it, if the ag use is currently being used for ag use, and they're willing to offer more than 10 times what you get in property values today for that tax revenue, what is it you're looking for, other than just holding this issue up?
Congressman, some of the issues you raise are significant issues, and on the money, let's talk about that for a second. I'm told there was a draft agreement some years ago where that was the offer. That wasn't based on any particular number. So in the Lytton agreement, for example, that you're looking at today, they're looking at a percentage, but we don't know what the number of people per household would be. There's no document that tells us how many new residents are going to be coming, and the tribe's environmental review said you're not going to have an increase in people because people who live in the valley will be moving
Have you
there.
been to their current reservation?
I'm sorry?
Have you been to their current reservation?
Yes.
Have you seen the housing?
I've driven by, yes.
The HUD housing that's there, I mean, do you see that as being acceptable housing? Can you see why they're looking to build new housing elsewhere?
I can see why they're looking to build new housing elsewhere, and the county has never said that they shouldn't build new housing. In fact,
They
we've
just
invited them
do
to
it
come talk to
under
us
land
about
into
it.
trust through the government-to-government negotiation.
I'm sorry, Congressman, I'm sorry.
My time is limited. Do you have issues with the current development under the current reservation? Developing a larger casino, larger hotel, any of their current issues that, are there issues that the county has with the development on the current reservation?
We did have issues with their expansion plans.
You did or do?
We do, but it's sort of a moot point at this point.
Why is it a moot point? You said something in your testimony which got my attention. It seems to me that because we have failed over the years to find any land use issue with the property that they're trying to develop for housing for their individuals, but in your testimony you mentioned that you had concern over the development on their current reservation. Now, I imagine you can't do much about their current reservation, the current developments there, but because you can hold hostage another piece of property, that gives you leverage to hold up something that may or may not be happening on their current reservation.
Congressman, we're not holding up anything on their existing reservation.
Okay, let me conclude. This is an issue of government-to-government relationships. The federal government is going to negotiate just as you would hope the local government would negotiate in good faith. This is not a geographic issue any more than the fine folks of Utah and the Red Rock bill that continues to come up every year with no members of the Utah delegation supporting something that other members continue to try to push. Or in my community where we need water storage and we have a coalition of members that are fighting for water storage, and yet there are members outside of our community that want to stop that water storage. This is not about a regional issue as it is about a self-reliance or a government-to-government negotiation. You either believe in tribal sovereignty, which many members in this body do, or you don't. We believe that we have to make up for the misdeeds of previous Congresses and misdeeds that have happened to Indian country throughout the country. And this is one of those ways that in a government-to-government relationship, in a fight for self-reliance, that this tribe, as well as other tribes, should be able to provide housing, medical facilities, and many other essential necessities to be able to have self-reliance for their tribe. This isn't about gaming. It's about being able to help your family, the same way that we want to help our families. We need to correct an injustice, and this is one bill to be able to do that.
Thank you. Thank the gentleman. Ms. Capps?
Thank you, Mr. Chairman, and thank you all for your testimony to our witnesses. Again, I'm pleased to have several constituents here providing their perspectives on H.R. 1157 and the complex issues involved. But I believe even our witnesses would admit that they do not represent the full array of views on this issue in the San Ynez Valley and throughout Santa Barbara County. As we know, we locals, there are fierce opponents of this bill, strong supporters, and many people in between who are not necessarily vocal about their views. This diversity of opinion on this local issue cannot fully be represented accurately in this setting, which is one of the many reasons why I oppose the legislation and oppose it moving forward in this committee. As I'm sure Supervisor Labanino and Ms. Maya Soto can certainly attest, when these types of local land issues and zoning issues are considered at the county level, the full array of interested parties can participate in the process, and they do, and voice their opinions directly to decision makers. Santa Barbara County has heard from hundreds of local residents in hours and hours of meetings, community forums, and hearings on these issues, as well as considered hundreds of pages of letters, legal filings, and environmental studies. But this diversity of opinion and in-depth debate of the many issues involved in this matter are not a part of today's limited hearing. H.R. 1157, which impacts only my district and is being considered today with only the limited views of 3 witnesses from the area and questions from a handful of members of Congress who do not represent the region and consequently do not fully understand the community or the complexity of the issues at hand. This restrictive process is not how these issues should be resolved. The BIA feat of trust is far from perfect, but it at least does allow for all interested parties to participate and make their voices heard. As I mentioned in my opening statement, the BIA has approved Camp 4 property being taken into trust, and several appeals of this decision have been filed. Director Black, my understanding is that these appeals of the Camp 4 decision are being considered under new rules from 2013 that speed up the internal appeals process. Is that true?
Yes.
Would you explain this new process? Maybe some of my colleagues are not familiar with it, under which this particular Camp 4 appeal is now being considered and the expected timeline going forth.
Yes, the Assistant Secretary under current regulations has the ability to take an appeal from the IBIA and make that issue that decision from his office. So he has exercised that right on this case.
Okay. And how does the appeals process for Camp 4 differ from the process used to consider the 6.9 acres that the tribe has been trying to take into trust for well over a decade? Do you expect the Camp 4 appeals to take as long as the 6.9 acres did?
And how much of it was at federal court?
Well,
subsequently,
right.
Upon issuing the decision from the Assistant Secretary's office, there is the ability to go to federal court. Now, that's oftentimes what happens, and as it was stated earlier, this went on for 14 years.
Right. But now there is a consolidated appeal.
There's a consolidated appeal before the Assistant Secretary, yes.
Have there been examples that this has been a shorter time frame?
I can't speak to that right at the moment, no.
Okay. Well, finally, if HR 1157 were enacted, how would it impact the consideration of the pending Camp 4 appeals?
It's my understanding that if this legislation was enacted, it would moot those appeals.
So there would be no further opportunity for any local appeals to be considered?
Not through our process, no.
I yield back.
That's my understanding.
I yield back the balance of my time.
I thank the good lady. Mr. Black, and again, you just hit a time frame on appeals. If my understanding, if it goes against the Santa Barbara County, that could be appealed to a court ruling?
Yes, sir.
And that'd be to what, a local district court, or would it be to?
I believe that goes to federal court, sir.
It'd be a federal court, but at a lower court.
I'd have to ask my lawyers exactly.
Okay, and then if that was lost, it could be appealed again to a higher court of the lower court?
I have seen that in the past with them.
And so what we're talking about is 14 years. That's really what we're talking about.
Yes, sir.
Okay. If I can, and this question will be a little short, Mr. Black, my concern is my bill. We've got a lot about all these other bills, but you know, the villages or the townships of the natives in southeast Alaska, I'm going to get Mr. Barlow later on, you keep saying, aside from precedent, the issue of identifying specific lands and administrative difficulty of conveying lands, does the department find any good reason to deny the Aboriginal land claims for the 5 Alaska Native communities? What is the precedent? That's what I want to know.
Sir, I'm going to defer that question to Mr. Ned, if that's okay with you.
You're on the hot seat, bud.
Okay. Well, I'm sorry, I don't have a...
No, he can do it.
Oh, okay.
Just say it, okay.
Thank you, Congressman, and I'm sorry, I didn't get your full question.
The testimony we have from you is precedent. You know, I always like to run the precedent. There is no such thing as precedent as the law. We make the law. So the question is, you use the word precedent, but is there any good reason to deny the Aboriginal land claims of these 5 Native communities?
Well, Congressman, it's my understanding that these 5 communities previously was found ineligible and appealed at, and 3 of them appealed at, and so therefore what the department is saying, if Congress was to move ahead and determine eligibility when they were ineligible, it would set a precedent and open it for any other community to do the same.
Only we can open it up.
Well,
you know, you see, there's no precedent. Only the Congress can do it. And that this is not an attempt to open up ANSC at all. What we're trying to say here is there's reasons why they were not recognized and why they were denied that recognition through the appeals process, because the law was written in 1971. But in 1971, when this law was written, and go back and read a little bit of history, the communities involved here all had large lumbering, timbering operations. And there was effort put into this Congress at that time not to recognize them because it might have affected the long-term leases of that timber. They were still Aboriginal people. They still had a right under the Lands Claims Act as far as being an Aboriginal settlement. And I'm suggesting respectfully, is there any other reason other than precedent? Don't you recognize them Aboriginals?
Congressman, again, right now what we have is the 1971 law that was passed.
That's right, and we passed that. Okay? You admit that. And what we passed, we can rectify. That's our role as this committee. And they were excluded by members of Congress at that time because there was an undue pressure put upon those that are not to be recognized that would have affected the leases from the federal government. You guys remember, from the federal government, wasn't from the state of Alaska. So they were excluded. What I'm trying to do is rectify that. Now let's see, 5 times, what is it, 27, Mr. Barlow, how many acres? 5 township?
Congressman, that would be 23,040 acres per township.
23,000, so we're talking about 5. How many acres in the Tongass National Forest, Mr. Black, you know?
I do. Somewhere here I had
it's 17 million. And so we're talking about little bits to justify the aboriginal right to those lands. And I always worry about this because there's this, it's mine. This is the Forest Service. This is the other agencies, ours. It was theirs before. And to take and be this small, not say it's their right, is wrong. And they're not asking for the barn or the farm. Every other community in the Southeast got, every village got these lands. But they didn't have this timber interest. And now we turn around and ruin the timber industry because you reneged on you didn't, but my administration reneged on the long-term leases. And now we have these 5 communities without land. It just bothers. Mr. Barlow, just a moment, I'll get you right to a minute. Why do you, I think I hit it, but why do you think they didn't give you guys land? And by the way, most of these Native Land Claims Acts started in Wrangell, way back when in 1903, and that was a hotbed of the natives in Southeast Alaska. They were leading forward the brotherhoods and et cetera, and they were left out. But go ahead, Mr. Barlow.
Thank you, Mr. Chairman. You know, there's been much speculation over the years, and there certainly is no record of why there was not a conveyance to the 5 affected communities. There are a lot of suspicions. Of course, the timber contracts that you mentioned, as well as activities for the Forest Service and in some respects by the state of Alaska, which didn't view native land ownership in the Southeast as a good thing. Frankly, there was a lot of prejudice in the communities at times too. But we really do not know why we were not included. And all we know is that the University of Alaska report confirms this. There is nothing on the record. So therefore, we will continue to pursue resolution of this issue because the battle isn't over yet.
I thank you. I can tell you in that period of time, a lot of things weren't on the record. Probably, some of it should have been, take care of it. I just want to thank you. And as you know, I've been pursuing this legislation for a long time, and I just wish my administration would excuse me, not my administration, with the administration would start looking at the amounts of land we're talking. We have the veterans can't do it. Oh, it's awful. And we have these communities, small pieces of land, and I do not believe in precedent. We set, if there's such a thing, the rules. And don't refer as your lawyer going back to the precedent's been set, because